Hi, this is John. I've been here with another podcast from the official California Apartment Journal, powered by AACSC. I'm the executive director, president of the association. We're here with our very special guest, Aaron Kohanim, and I really appreciate it. You've been around since 2019, so yes, I want to hear, what's your origin story? Like, tell me who you are and how you got into law.
So basically, went to high school, went to SMC, UCLA. From there, I took a career test. It's called the Myers-Briggs test.
Okay.
Which determines what type of career you're supposed to go on.
I remember those.
And it gives you like 4 letters and it dictates your whole lifestyle, your background, whatever. And it said law.
All right.
So then I chose law.
Really?
Yes.
Okay. So you're at Santa Monica and then you went to UCLA?
Yes.
So you're an LA kid?
Yes.
Through and through, right?
Yes.
California forever then, huh?
Yes.
That's good. And so after graduating law school, you decided, I'm going to go into my own practice? Or did you work somewhere beforehand?
So I applied to a bunch of places to work. No one would hire me. So last resort, I opened up my own firm.
And the best decision you ever made, right?
Looking back, yes. So I opened up my own firm, but that was 2019.
Yeah.
And then the biggest thing happened, which was COVID.
Yeah.
So that kind of destroyed my business route focus. So then I ended up working for someone. And then while things got back to normal in the economy, then I went back to my own.
That's awesome. When you went to get the law degree, you specialized in real estate pretty early.
Yes. I also had my real estate license as well. It's not active anymore, but...
Was it a broker real estate or just salesperson? Okay. So you had a very extensive background then. It was even before you were an attorney then.
Yeah.
That's great.
I also went to USC Lust for a program as well.
Yeah. Okay, so you double whammy then, right?
Yeah.
So listen, I have a list of questions that my staff came up to ask, but I mean, here's what I'm seeing, okay? You have a situation where it used to be that housing providers, AKA landlords, and we'll have a discussion about that too, really the relationship between them and the tenant was really on their own. It was essentially like they felt their business needed to do in order to have that relationship. And I would say that over time, there's a third partner now in that relationship, and that's the government, right?
Yeah.
And it's playing a more and more active role, whether it's you see these policies for anti-tenant harassment policies, county and municipalities paying for, mandatory legal defense for evictions. What are you seeing that is triggering that? I mean, I guess I would ask you, is it that there's an overreaction to a handful of bad apples, or is there a systematic problem within that relationship that you need that much government intervention? Or is it just that they're really effective in advocating for tenant rights? In other words, is there a true problem to solve with these laws that they're creating? Or do you feel that it's an overkill based on your experience and what you see happening?
So the biggest turning point was COVID. I mean, before COVID, there was just rent control. The standard rent control on a multifamily property that was built before 1979.
Right.
That was just the base.
That's for Los Angeles, right?
Just for Los Angeles. Right. And other municipalities.
Well, yeah, there's
too.
several of them, yeah.
West Hollywood, Culver City, Santa Monica, all of them.
Right.
And then when COVID hit and when the moratoriums went into effect, saying you can't evict for these reasons or you can't raise rent and you can't do all these things, that's when the cities decided, you know what? Let's take these temporary solutions that they call and let's make it permanent. And one of those permanent things is now there's rent control, which controls the rent. And then now there's eviction control, which controls the reasons you can evict.
Right. So just cause and all those other things that are
yes. All synonymous. So eviction control is now all over LA City and West Hollywood and Santa Monica and everywhere else. And then on top of that, the state also decided to pass their own thing as well.
Right.
The Tenant Protection Act of 2019.
I think you're right. I definitely think COVID was it was an extraordinary time, which called for extraordinary measures. And certainly I think in sort of a reaction to this pandemic, this once in a 100-year event, the legislators assumed a certain amount of power that they were able to yield. And since then, they haven't restrained that power, right? They're like, wait a minute, we can do these things. And so let's do some more, right? I wonder though, if it's causing more problems than good. I mean, I know that, but like, do they see that? Do they understand like what they're doing is essentially making it harder to rent to tenants who otherwise landlords would take a risk on? But now they're so disincentivized to doing that. It's like all about pre-screening, right? It's about legal forms of discrimination to make sure that you have a tenant that is going to pay rent. A good tenant pays rent, right? I'm wondering though, don't you feel that these rules and restrictions and the fact that there's different jurisdictions that are having them are actually causing more problems for the people that they allege to protect?
Yeah, I think so. I mean, they're making it so that you're forced to take on more tenants,
right?
Rather than the regular background checks and everything like that. For example, there's now a new law that says source of income discrimination.
Right.
Meaning you can't reject someone.
Criminal background.
Section 8, yes.
All of that.
And then on top of that, they're now making it even harder to evict.
Correct.
So now once you take in a tenant, now it's harder to get them out.
Right.
Now, I think it's the legislative intent that they want to cure housing and homelessness and all that stuff.
I get it.
But I don't think it's going to cure homelessness.
No, it's making it worse.
It's not. Because what I was telling a colleague of mine, a client of mine the other day, is that let's say a tenant throws a house party.
Right.
Biggest raging house party, right? The police come, the neighbors come, everyone comes, and they're now complaining.
Right.
You now have an evictable cause under nuisance, right? There's a substantial and continuous interference with the quiet enjoyment of the property. Even the police come, right? Now we filed the lawsuit. We filed the eviction. We're now in trial. Landlord comes and testifies and says, yo, this was a crazy party. This is a nuisance.
Yeah.
You now have the
tenants. Other tenants are like, these guys got to go.
The neighbors are coming saying, hey, this guy has to go.
Yeah.
You can also bring in a police officer.
Sure.
Who came and said, hey, I saw this party. This was a rager. This is what's happening. There is a nuisance.
Right.
On top of that, even the tenant can come and say, Your Honor, this was the craziest party of my life. Okay, this was a rager.
Right.
Meaning he admits to the nuisance.
Right.
Case in chief is done for the landlord. And now you have the tenant lawyer comes.
Right. Tenant
lawyer asks the landlord, did you mail a copy of the rent certificate?
Right. Right.
And the landlord's going to be like, what are you talking about? This is a nuisance case. This has nothing to do with rent. No, that's not the question. Did you mail a copy of the rent certificate? And the landlord's going to say, no, I didn't. Case dismissed.
Out. Yeah. Yeah,
you can have all the facts, everything done. Case is done forever.
Agreed. I'll also say this, Aaron, we have a lot of members that are do-it-yourselfers. I mean, we have forums, we have office hours where we have professionals come on and give advice and counsel. Aren't we in a moment in time where essentially they should have an attorney on file to run this process through? So when they have that event occur, they contact you first.
100%.
Right. I mean, how many times do you get a case where the premise of what happened unwinded all of the clock of the work that's been done to the second that you got it?
100%. So what I tell people is, in eviction court, there's only one way to win, and there's 1,000 ways to lose.
I like that. Say it again. I actually think that's a good one, Aaron. I like that. Yes.
But there's 1,000 ways to lose.
Right.
And if you don't go through a checklist before you end up in eviction court, as long as I get one of those 1,000, tenant wins. And you need to make sure that you check off every single thing. And unfortunately, the city of Los Angeles and also the other municipalities have engaged in hyper-regulation.
Of course. Well, I think it's on purpose, right?
Yeah.
I mean, we were fighting a thing in Long Beach where it was presumptive guilt. Like the way that the ordinance was written is like the landlord is guilty, and it's when it goes to court, the judge views it and he has to whatever the word is, find it, has to have a legal affirmative defense against the action. These are for the eviction. It was due to renovations that if they lied and the tenant sued, it would have been a presumption that they were against it. I'm like, but wait, isn't there an issue of fact still, right? On many of these cases, right? Which we'll get into later.
But what I wanted to say is not to attack property managers or real estate agents, but it's getting to a point where you do need an attorney.
Well, let's be honest, Aaron. It's not a knock on that. I think they need them too, right? Because what is happening is every jurisdiction is different.
And every jurisdiction, every single month,
changes it
new, so no one can keep up.
100%. So, and I also think it's money well spent. Like I work with compliance attorneys for, some of the stuff we have to register, we have to not register, whether if we are advocating for tenants, for instance, right? And there's certain jurisdictions that require you to register that activity because you're essentially lobbying or presenting your case. And there's cases where the compliance attorney is like, yeah, it doesn't meet the criteria. Well, we'll just put our name down anyway. It's like, no, it actually makes it worse for you to do it when you're not doing the activity versus. So it's everything is a nuanced approach. And when you think you're doing the right thing, you have to have that specialization to know. So essentially, most evictions today require some sort of legal advice and counsel. Wouldn't you agree?
100%. And just for people to know, I spent like a couple hours creating a blog of literally 14 things, checklists.
Right.
What you need to post, what you need to file, what you need to serve.
For all the do-it-yourselfers. But even then, I think what ends up, I see it time and time again where, they, like you said, 1,000 reasons to get your case denied. And it's like penny wise, pound foolish. If you got the legal representation up front, you still have a journey, right? I mean, there's a process. There's a game that tenant advocacy sometimes play where they're sort of on purpose. Like I've seen the letters, like, did you know that you can drag this out for, an extra time because we don't want people to be homeless or they don't want to be, but it's designed to sort of keep people in housing when there's transition. And just to be clear, I'm not unsensitive to tenants, right? I just think that if you were to look at a bell curve, most people live in the middle where a conversation can solve 99% of the problems.
So one of my biggest advice to landlords is even before you file the eviction, serve a warning letter.
Right.
Just say, hey, you are in violation of this clause. Please fix it.
And we're seeing that bill from 3 days. Now they're wanting 14 days and, to give notice for a 3-day vacate. Now it's
so Santa Monica has this requirement actually.
Okay.
That before you serve an eviction notice, you have to send a warning letter for the eviction notice. And I think it's good because at least you now know what the tenant is going to say or what's their side of the story. Right. And if it's fixable, you can fix it and you can prevent the eviction.
Yeah. Let me speak on this a little bit because I always tell people a little bit goes a long way, right? So when you have it, you're providing a service, right? You're providing, this wonderful residency, ideally it's nice to schools. I mean, people want to live in the best place they can afford to live in, right? So even if it's, a little bit more challenging neighborhood, right? It's still an experience. And I always tell people get a little gift basket, welcome them in. It starts the conversation relationship, whether you're a management company, whether you're a mom and pop owner. But a lot of people feel even now with those conversations because of the tenant harassment ordinances, they can run afoul of it, right? So we see many times where somebody will, do a habitability claim or some sort of issue relating to, perception of mold or whatever they might be saying. And then they get a rent increase and they're saying, it was because I complained, right? I mean, you're seeing, and I think it may not have anything to do with that. Most of the time it doesn't, but that doesn't stop someone from making, hay from that type of situation. So as it relates to habitability, what I tell landlords and housing providers is document everything.
100%.
What does that mean to you? As a counsel, as an attorney, what's the advice you would give our members as it relates to what it means to document and have third-party validators, right? That's the other thing.
Everything you write, the judge will read. Whether it's text messages, a letter, or an email, all of that, the judge will read. Right. It's part of the record. It's part of what we call discovery, meaning you just provide everything to either side and the court. Everything needs to be written down. Everything needs to be memorialized. And you need to say, hey, tenant, this is what's happening. This is what's going on. This is what's going to happen in the future. When it's not memorialized, then it now goes, he said, she said, this is what's happening. This is what's going on. And then on top of that, once a tenant gives you written notice of an issue, be quick to respond. Right. Don't just hang around.
The clock started.
The clock starts. That's exactly the word I use. So the moment the tenant gives you notice, the clock starts. And the biggest thing I tell landlords is you need to end the clock. Correct. I don't care.
Put the ball back in their court.
I don't care about how much you want to pay them or how you want to resolve it.
Agreed.
Just go in and get the repairs done.
Or even do the assessment, because what you'll see happen many times, as you know, they'll make the claim of an issue and then you try and make it I'm not available that day. They're difficult, right? And it's annoying.
So at that point, you need to memorialize all of that.
But it's interesting. People don't do that. It's don't. It just doesn't happen because they come to me with a long story. And I'm like, great, show me the file. well, we're happy to help you. And they're telling me a lot of things, but I'm not seeing it, right?
So the tenant denies you access. You write in a letter, dear tenant, you denied me access on this date. I am available on this day, or please let me know the time and date you are available. Or you were served with a 24-hour notice.
Yep.
You denied me access. So please let me know. So that way now you put the ball in their court.
100%. And Aaron, let's also say this too. Hit the reset button. Just because somebody is nuisance to you because they're constantly saying that there's something wrong and, you go and you investigate it and it's like nothing was there, doesn't mean that the third time they did that issue is not that it's nothing, right? So I always tell people, meet people with grace. So, because to your point, the judge is going to see it all, right?
Right.
So
or a jury. And I tell people when we go to jury, you have to think about all 12 of the people sitting there are all tenants.
Right. That's right. Well, or most of them are for sure.
But we have to take the assumption that they're all tenants, and they're going to ask themselves, as a tenant, do I want this tenant to vacate?
Right. And is it reasonable? I think what they do is they look at the record and they say, did this person act in a way that was professional, courteous, reasonable, and timely, right? Would you say that that's like number one advice as it relates to habitability issue? Because you're seeing more and more of those cases, aren't you?
Believe it or not, I do both sides.
Okay, fair enough.
But yes, there are more of those cases.
So wait, so you do the tenant side too?
I do tenant side as well.
Okay, let's hear it. What are you seeing?
My barrier of entry on taking a case against a landlord is that there needs to be a government report. Okay. So meaning not just one or two letters coming in saying there's issues or whatever. That means the health department or LAHD has now come in. They see that there are violations present. They've inspected it. They've now given a report to the landlord. Mm-hmm. Now the landlord has notice. And then the city or the health department gives them 35 days by law. Mm-hmm. If they fix it, cool. But some landlords, 35 days, they don't even fix it.
Talk to me about those landlords. What do you prescribe the issue to be? Is it the property management company? Is it they don't have enough money, like they have a smaller portfolio, so they don't have economies of scale? They're used to doing business a certain way. I mean, what is the zeitgeist?
I think it has to do with neglect, not caring.
Okay.
Or they do a Mickey Mouse job.
Like just enough.
Just enough.
Yeah.
Because if the same issue happens again within a certain amount of time, it's not fixed.
Yeah.
Or you're not spending enough money, or you're not doing it properly,
And I'll just say, like, I have no tolerance, even though I represent housing providers and I want housing providers to be successful, but there's a few bad apples that make it hard for everybody else. I wish that we could reach those people and explain how difficult they're making life for everybody else. When there was a moratorium on substantial remodels during COVID, they kept talking about, there's all these advocates that showed up and they're saying there's all these eviction moratoriums are happening. And I'm like, I don't see it in the marketplace. We did our own investigation and because we could actually pull the data of people who pulled permits. And there were two properties. There's 7,800 properties in Long Beach, right? 6 units or more. And the two, I reached out to them. So one of them was purchased recently and we're starting the renovations before the moratorium. And they were halfway through and they would lose a lot of money if they had to stop. And so the guy was like, look, I'm going to have to pay the fine. I'm going to have to deal with it. And I just said, look, there's got to be a better way. And let's have some conversations about how we can manage this. And then the other gentleman literally was like, I don't care, right? And despite me saying, look, an entire legislative process is occurring because of you, right? There just doesn't seem to be the mindset of understanding like how that impacts us. Because I just think there's examples of extreme, there's tenants that abuse the system. Clearly there are, but there's landlords that abuse the system. And I just feel like it's a missed opportunity for everyone because we're over-regulating to the point where people are no longer talking to each other. I mean, most housing providers, landlords, will work with their tenants. Now, what's happening, is that people like you very cleverly say, and I'm not disagreeing with this advice, is get that 3-day notice out right away and then have a conversation. But you have to start the clock, right?
Right.
Through that process. Before, it used to be more of, hey, I'm going to be a little bit late. I'm going to have, there was a conversation that started earlier in that process that it's almost being discouraged at a government level where people are no longer talking to each other and figuring things out, right?
I think it's because the process takes so long.
Yes.
That they want to start the clock.
I get it.
When the average case is now taking 3-4 months and the sheriff department is now defunded. Mm-hmm. So rather than being 5 days per code, but now it's 2-3 months, which now gives you a total spam of 6 months.
Right.
Then it's like, I don't know how I can talk to you and work this out. That makes sense?
Yeah, it does make sense. I mean, where's the end? That's my problem. I feel like we're on this, like we're all driving to this cliff where it's just this, sort of this austerity, between housing providers and tenants. And I actually think housing providers care about their tenants. Like they shouldn't be giving loans and doing other things, but they do have an invested interest in having their tenants be happy and vice versa. I think tenants that have a great experience, have a good relationship, they enjoy where they live and, things get taken care of when they're supposed to be. There's a sense of professionalism and fairness that their housing provider or landlord deals with them. There's no issues,
As one friend of mine said, I only see the bad. Right? Because
I hear it all the time.
I'm the attorney.
Aaron, I hear it all the time too.
I only hear the bad. They say like 95% is good, but then I only see like the 5% bad.
Right. Okay. We have many profiles of property owners, those that own, 100 doors up to, mostly 15 doors down, right? In total number of units. Mom and pops. Most of our members are mom and pops. And they are do-it-yourselfers. When they're like talking about their balance sheet, it's like a notepad. It's not even in an Excel, right? I mean, they're like
I'll be asking for the rent roll. They're like, I don't know what that is.
It's like a journal. Yeah, it's wild. So, but it's okay. Look, it's worked for them. But my advice is to engage with legal counsel earlier in the process, because what I'm unfortunately seeing is they'll come to me or our association, and typically what happens is the journey started with like one of those thousands ways to not start that journey, right? And so how would somebody go about engaging with you? Like what is it that, obviously they would do it before they do an eviction proceeding, right? Where they do the file paper. When would they normally come to you, and how would that process work?
So I would recommend they come before we serve the eviction notice.
Okay.
So before you intend on serving the eviction notice, let's do a property review. Let's make sure you paid all the fees, posted all the signs, put the property in compliance.
Right.
Because what happens is, as you were saying, they learn it the hard way. They'll start the case with me. We'll be in the middle of the case, $10,000 in, 3 months in. Tenant lawyer comes out of nowhere and says, you don't even have the RSO certificate.
Right.
And I look at the landlord, I'm like, case dismissed.
Right.
And they'll be like, I don't know about that. I'm like, I don't know either.
Right.
Because I'm not a property manager. I am just an attorney, meaning it's my responsibility to just review court stuff. And then they blame me saying, well, you didn't tell me. I said, I'm not the property manager. Who is? And they're like, it's me. And I'm like, sorry.
Yeah.
Case dismissed. You have to start all over. And then now you're going through the whole checklist again, and they're upset and whatever. And
it's costing them more money.
More money.
Penny wise, pound foolish. Yeah.
So you just lost thousands of dollars on me, even though I like money, but it still sucks. And then you lost another $1,000 on rent because you can't collect rent in the middle of the case.
And future rent. You could have rented it out earlier.
Sure.
If they were evicted on time.
And then you just lost 3-4 months. So now you're back to the beginning again.
All right. So come to you before they evict.
Yeah.
All right. I like that. What other trends, like if you had like, here's my top advice for people to think about it, because obviously there's habitability, notices, compliance, eviction, how you lease up, I always say that we have forms, but it doesn't know your property, right? It doesn't know what's unique to your property, because you can customize it so that, everything's kind of spelled out. More and more we're doing that. What other industry trends are you seeing, or what are some things that you're seeing happening that housing providers need to be thinking about?
That's a good question. I think just the RSO rules is what needs to be done, because I do evictions. So you just need to make sure you're on top of your laws. It's a hyper-regulated environment. Mm-hmm. And it's always changing. So that needs to be looked out. And then in terms of trends, I don't know if you're aware, but a month ago, they just passed the Notice of Right to Counsel.
Yes.
So
you have to post it, right?
You have to post it, and you have to serve it.
Yeah.
Right. And you have to post it in the language of the tenant.
Of the tenant.
And if you don't know the language of the tenant, then you post it in all 8 languages.
Wow.
Okay.
And again, it's one of those things like if you didn't do it and you didn't do it right.
Oh, case dismissed.
Yeah.
So that's my favorite word.
I feel like we should do that meme. You know that
case
meme?
Dismissed.
It's like jail for you. You go to jail.
You didn't post, case dismissed. You didn't file, case dismissed. That's it. So now more and more cases now have free legal lawyers. Now, am I against that? No. I mean, tenants have rights. It's part of due process to make sure everyone is validly being evicted.
I have some thoughts on that, but go ahead.
Right. So each side should have rights and representation, but now you can't get away with not knowing the rules and the RSO. you have to be on point. You have to make sure you know everything because there will be an attorney on the other side.
Yeah. I think what's interesting is like many of those COVID cases, as you brought up, by the time they adjudicated and went through, truth came out in those proceedings that most tenants, and I don't want to disqualify myself, but I feel comfortable saying this, and if not, I want you to challenge me and throw it back out. But most tenants that self-declare were invalid. They were not impacted by a job. They were not impacted by job loss. They were not impacted economically. They just heard from the government, I didn't need to pay rent, and they stopped paying rent. And it hurts me as a taxpayer that they got a right to counsel. So that was money away from somebody who was impacted and may have needed those services, but they used those services only at the end for there to be a verdict against them, right? Where they have to pay. Now, good luck trying to find that money. And, there's debates on whether you should or shouldn't continue to try and get that or not. But, in the recent fires, right, the moratorium for the fires, I said, look, why not put at a minimum suitability where they verify that they were impacted by the fires?
So for the fires, they did do that?
Not to the extent that they needed to. I think that it was based off zip codes, right?
It was zip codes and also self-declaration.
I understand that. Well, self-declaration is one thing. I'm talking.
It's much better than COVID.
It was slightly better than COVID, but I think
oral notice.
Right, you just self-declare verbally. Yeah. This is now written, but I think look, if you were to get unemployment insurance, okay, you have to show that you're unemployed. You have to show that you're trying to get a job. There's certain steps you have to make to get that benefit or that assistance. This demarcation is not enough. That was our argument. We can agree to disagree on that, but I just think that the lessons were learned during COVID, if you're repeating many of the same things again, where people are going to manipulate it and abuse the system. And that hurts the people who actually need those protections and actually need those help. I mean, that's just my feeling.
To be fair, I haven't seen any fire-related defenses.
Okay.
Not like COVID.
Right. Well, now we're doing it because of the economy. That's the new one that's coming out, right? Like, ICE raids.
Yeah, I don't know if that got passed yet.
There's no problem. This is the thing I don't get. Like, if you think people should have food, which I agree is a good idea, you pay for it. You have a SNAP program or EBT. You have funds that you dedicate towards doing that activity. If you feel as though somebody should have health care, you pay for it. You write a check and you create a model and then you create clinics and you're able to have it. If you feel that housing is like a human right and you should have it, you should pay for it. I don't know why private owners of private property need to subsidize at the whim of these policymakers. I just think that, and by the way, the landlord...
Actually, speaking about that, another industry trend that just rang my bell.
I love it.
Is more and more landlords are now taking Section 8 because it's easy confirmed rent money.
I've been advocating Section 8 forever and a day. It's guaranteed. Yeah.
So more and more are now taking Section 8. And now word on the street is they are paying above market for certain units.
And look, I think it's like a government way of sanctioning your property because they come in, they inspect to make sure everything's so you don't have these habitability issues.
These other code compliant.
Because it's all up to snuff and you have a piece of paper saying you're Section 8 compliant. So I actually think it's a great thing. I've been a long advocate for Section 8. I think, again, people who historically have owned properties, they don't like that third person in that relationship, which is the government. But they're already there. They're there whether you like it or not. Why not get the guaranteed income is what I don't understand.
So here's where I think you come in.
Okay, let's hear it. Let's hear it.
I think we've reached a point now where people have to now do constitutional challenges to these laws. Meaning a landlord can now file a lawsuit to challenge a lot of these hyper-regulation laws.
Yes.
But the problem is, and where you come in, is one landlord can only defeat or attack one law. But an organization like you, which represents all landlords, you can actually challenge all of the laws.
Yes.
And I think that's where you come into play.
Yeah, I think so. There's a couple of cases that are working there through. We've got one that we think, I'm trying to remember, that was recently at a federal district court that said they had to pay it back, and it's being appealed for basically the taking clause that you created, and this is from COVID. And so I do think that there's some potential for a judicial clarification on what can happen and what can't happen.
Yeah, so like the law about needing to file the notice with the city before filing with the court.
Yep.
If you ask me, I don't think that's constitutional.
Okay, let's hear it. I want to hear it.
So how our system is built, our government system, is that each level of government has a responsibility.
Yes.
And when it comes to federal trumps state, state trumps city. The state of California has said that we are now only responsible for laws that are procedural when it comes to evictions, meaning how to evict and what steps you need to take to evict. That's state law. But if it's substantive, then that can be city law. So for example, a substantive law would be eviction control. That tells you all the reasons why you're allowed to evict, or rent control. It tells you how much you can increase the rent. But procedural means, how do I evict? What steps? So if you ask yourself, what would it be procedural for me to file a copy of the 3-day notice with the city before filing with the court? I think that's yes. It is procedural.
Sure.
Because if you don't follow that procedure, case dismissed.
I agree. I think you're right. I think you're right on that. You're also not allowed to expand it, right? So if they give like a certain number of notice, the city couldn't say, well, actually it's 90 days, not 60 days, right? You can't expand what the state is prescriptive for. Does that sound right?
The actual eviction notices?
Well, or whatever timeline and dates, like where they're trying to extend the 3-day, only the state can do that. It's not something that LA can do or Santa Monica can do,
Technically,
right?
that would be substantive.
It would be substantive.
Yeah.
Okay.
It would.
Because it's not preventing them from doing it. It's just giving what the timeline is.
Yes.
Okay.
So it's about how to evict, not what to evict. The rights and obligations.
Okay. What about just cause termination? Why are they able to?
That's substantive.
Okay.
That's all the reasons why you're allowed to evict.
Lease termination is different than eviction.
Lease termination is substantive.
Correct.
That controls the lease terms.
Correct.
That has nothing to do with procedure.
But under state law, you have the right to cancel a lease in the first 12 months under
1482.
1482.
So it's the Tenant Protection Act.
Right.
Well, it depends what type of lease you have.
Well, but
that's state law. But we're in LA County where state law 90% of probably 80% doesn't even apply.
What do you mean it doesn't apply?
So state law says if the city has its own laws, then you don't follow the state.
Okay, gotcha.
So for example, Long Beach has its own rent.
It's prescriptive. It's prescriptive. But isn't that counterintuitive to public policy? Wouldn't it be more of a statewide rule versus all these different cities that have different rules?
So what the state did is in the Tenant Protection Act, on the last sentence, it says, if a city has its own, you follow the city.
Prior to that act, or does it matter if it's before or after? Or just that's what it is? Yeah. This is the stuff that drives me nuts, right?
So now you're not playing legal jiu-jitsu to figure out which level you're at.
Yeah.
So for example, if you're rent control in LA City, both rent control and eviction control is with the city.
Right.
But if you're in a single family home, eviction control is with the city, but rent control is with the state.
For now.
For now. For now.
For now. I mean, let's be honest. I mean, I tell people, just wait. They're coming for you. That's the thing. I feel,
Will the city of Los Angeles pass rent control on the houses? Probably not, because of the, not Ellis Act. There's another law. Acosta-Hawkins.
Yeah, Acosta-Hawkins, which they tried to repeal last year. So I tell people, like, it's going to get worse before it gets better. So I think like Prop 13 still in play. I think they're not going to, change the little old lady from Pasadena and her property taxes. But I think for multifamily property owners, they will, right? Because we are a target. Let's just be candid.
Well, you already have the mansion tax right now.
Right. Well, and it's a disaster. It's a complete disaster, right? I mean, and they've thought about it in other areas, and I try and explain to them why it doesn't work. But yeah, the mansion tax, all these things. I just worry, one of the, and I meet with a lot of these folks, right? I always ask, what problem are we solving? Like, I want to be a partner in...
It's hyper-regulation. That's what it's called.
I get it. But what problem are we solving? Like, how are any of these things making life better for anybody, including tenants, right? Like, I understand that the data of right to counsel doesn't quite add up, right? Where many of these cases are frivolous, right? But then I hear, well, that's the stated intention, is to keep people housed longer. And I'm like, but is that really what's happening? Or are we manipulating the system to allow them to have longer time to get the cash for keys as leverage? And, there's all these like leverage points of what's actually happening in the marketplace.
There's a lot of leverage points. There's a lot of what we call legal extortion happening in these cases.
Right.
The tenant owes like $20,000, and then the tenant will ask, now I want $20,000.
That's right. I see it all the time.
And the landlord's like, what? Why am I paying him when he has to be paying me? And I'm like, I don't know. You want to take it to trial? They're like, what do you mean trial? I'm like, you want to hit the casino? I call it the casino. I call trial the casino. Used to spend like an hour explaining how trials work. And I found one word, the casino.
Yeah, it's the casino. Good luck.
Like, is the house against me? I'm like,
yeah.
Vegas. Oh, of course the house is against you.
In your experience, since you work both sides, which I actually really appreciate, because I think, it shows the true expertise, quite frankly, right? Because you see it from both sides. And, sometimes you shouldn't ask the question that you don't have the answer to, but I'm going to ask it anyway.
Okay.
Is it more abuse on the housing provider side or the tenant side based on your experience? Abuse in the legal system. In other words, taking things to court where it shouldn't be taken to court, that there isn't a reason for the eviction or a reason to try and fight the eviction. Or do you think it's about right?
With me, I actually do a intake process. I'll be like, how do you know? When did it happen? What's your evidence? Right? They'll be like, oh, there's an unauthorized person living there. I'll say, okay, how do you know they're not a guest? Maybe it's a nanny. Maybe I cast doubt.
Sure.
Because if you don't cast doubt now and then we go in front of the judge,
it won't stand the test of time. Right.
Right. So I don't like taking these easy, weak cases because then it makes me look bad and then it looks bad in front of the judge.
Well, you're not doing any benefits to your potential client if you're
right. Now we were 3 months in, $10,000 deep, and then
so how come I'm not winning?
Yeah, exactly.
Right.
But is there abuse? I mean, from one perspective, the landlord's is abuse. From the tenant's perspective, it's rights.
I get it. Look, I mean, I actually spent I was going to be called as a witness on something, right? And I had to hang out at the courthouse. So I just sat in and listened and stuff. And there were a lot of people who were getting evicted and they didn't have an attorney, right? But it was like this. Right. Which, by the way, is still a long and protracted process. It's not like they're out that day. And then on the other hand, I hear stories from a lot of housing providers who are seriously being screwed over. And,
right. So
and
now we
legal
go back
ninjutsus.
Now it goes back to my nuisance example I gave.
Right.
Right in the beginning of our talk. You can have the landlord, the housing provider, all the neighbors,
and it still doesn't matter.
And the police officer.
Still doesn't matter.
And you can have it all on video. And you can have the tenant admit. Still doesn't matter. You can't evict.
So let me ask you. So since there's public funds being used for affirmative defenses, whether they deserve it or not, and I mean that wholeheartedly. I think there's many of these cases that are absurd. As an industry, though, shouldn't we pursue it to the ends of the earth then? Like if they're going to clog up the legal system and create problems, isn't it behoove us to then, if we're in the right, to take it all the way? And if we started doing that as an industry, would it change sort of the way that they're using the outcome? And I'm asking a question I don't know the answer from.
Every case, so there's a constitutional right in the state of California to request a jury trial.
Right.
So that means you would have to take every case to jury.
I understand that.
Problem is a lot of landlords don't have the time and money to go through jury trial.
Okay.
To sit there for 5 days in front of 12 people, present your case.
And it may not look so sympathetic depending on what the circumstances
are. I've won at jury and I've lost at jury.
Sure.
Right. And I've come to realize jurors, they
kind of do what they want.
Yeah. But they also focus in. They're like, what is going on? What is happening?
Right.
So if landlords want to take it to jury, they can. But according to you, they should force.
I'm not saying they should. I'm just saying, what is the relief, right? I feel like look, I'll say what I'm doing on the policy side. So what I'm trying to do is I'm trying to really nail people down to specific cases and examples. And then if it's prolific in the industry, is it really happening? Like, are we seeing, a lot of these, tenant groups and tenant unions and tenant advocacy, they'll come to council, they'll come to the board of supervisors, and they've got a story.
Right.
And then I look into the story and it's not true. There's a nuance to it. There's a little bit more
of the story.
One of our clients did a renovation, right? And this is I don't want to speak for him. Long Beach. So he did a substantial remodel, went to the city, filed out all the paperwork, did the whole thing, and the person protested, and then the city wrote him a letter saying, well, it's not substantial enough.
Right.
So then he's like, all right, well, I'll get engineering drawings. And by the way, something we're working on is they'll never say when it is enough, right? They'll just accept your application and be like, all right, well, we'll see you on the other side. So I do think that there could be clarity in making the determination of whether it is or isn't substantial. I mean, you call the strikes, you should be able to call the home runs too, right? Like if someone gets it right, you should say this is a material substantial remodel, go do your bidding and follow the rules of relocation.
Yeah,
fees
majority of my cases, I don't have substantial remodel because it's not allowed.
No, right. Well, in LA, yeah.
Yeah, in LA, West Hollywood, Santa Monica.
Which is wild because then they do and I'm sorry I'm all over the place, but they want them to spend millions of dollars or hundreds of thousands of dollars retrofitting. Yeah, or retrofitting even these new earthquake standards and stuff. It's like, okay, well, how are they going to do it when their insurance costs through the roof? And I'm sounding like my members right now, just complaining about stuff. I'm like, well, that's the business we're in. So they went in similar fashion and situation because the initial paperwork was incorrect. He went through all the way to the process and then got it case dismissed. So now he's starting it over again because, of course, she hasn't paid rent in over a year, right?
Right.
So it's like, okay, now I'm just going to do it based on this, not this other thing that I was working on. And hopefully he'll have a little bit more success as he goes through that. But I just think, I forget what the original question was, but like, I just think that when you kind of drill down on it, you know, when I saw that the city was able to say whether it was it or was not it, right? And only could say that it wasn't it, not that it was. And I don't like that ambiguity. I think that we should be able to... So
that goes to the constitutional challenge of procedural.
Yes.
You can file...
I don't know, you got me going here. What are we going to do?
Yeah, should we file a constitutional
you want to start
because the cities are not supposed to dictate like whether you win or lose.
Right.
That's the court system is for. That's due process. So that's a constitutional challenge right there.
I like it.
Right? The city cannot prevent you from going to court. So there's a Supreme Court case that says cities cannot cause a chilling effect on landlords filing lawsuits.
Well, it's ice cold in LA. I mean, but no, I hear you. Yeah. All right. Well, look, I think if I were to sum this all up, and I really appreciate your time and your candor and a lot of really insightful discussion, and I kind of came in with a bias. I think that the best money spent is hire the lawyer early.
Yeah.
Avoid.
I agree with you.
Yeah. Well, I mean, so like there's landmines you can see, and then there's landmines that are undetectable, but they are to the attorney because you've seen it all, right? You know where all the landmines are, and you could probably spot a case from a mile away and know if there's something that's material substantial that you're going to have probably a likelihood. You never know with jury trials, by the way. It's like it is like a casino.
Yeah.
But you can say that there's a high likelihood that you'll be successful, and those are the cases that sounds like that you take on, or to approach the problem with a different nuance, right? So that you can coach them through how best to position themselves to achieve the outcome or obtain what it is that they want.
I feel bad for landlords because they're like, they owe me $15,000, but yet they haven't done anything of the rent control.
Right. But that's because they're coming to you late.
Yeah.
So what I'm saying is for a few grand or whatever, start the journey with you.
Yes.
Before it becomes a case. And then that way, when it becomes a case, the foundation's laid.
You got it all done.
Yeah. And I just think that, especially in today's environment where the county, the state have so much money, affirmative defense for all tenants, right? Basically, if you're a tenant and you want legal aid or any kind of like legal protection, they don't have an intake form that says, hey, you probably shouldn't fight this eviction proceeding. It's like, we're going to help you, right?
Yeah.
So, and they advise not to settle, by the way. That's the other thing. I've seen the letters. I mean, I don't know if you've seen this too, but
I'll tell you this past 2-3 weeks with the legal aid people, defense counsels, we have settled.
Really?
Yeah.
Oh, it's changed then.
Yeah.
What would you say that's for? Because they want to do more? Some metrics behind
too many cases.
Yeah, that could be that. Now that they're doing more. Yeah.
Yeah, they're doing more, so they have.
So therefore, they might as well get settlement. They get a little money in their pocket, and they can move out, which they probably would have gotten anyway. By the way, I'm just for whatever it's worth.
Some of them fight tooth and nail, and some of them will settle.
Well, and also be careful when you settle, right? Because I've seen that too, where they settle, they've taken the money, and then they don't leave.
That's the problem with the attorney you have. Did you say only upon timely vacate? Or did you put the money in a attorney trust account, which is...
Well, these are for the do-it-yourselfers that I'm seeing. I'm not seeing this, they think because they're used to doing cash for keys a certain way, not realizing that the systems have changed. Anyway, go ahead.
Hopefully, like when you make a deal, you did it with like a judgment form. So that way you can automatic lock out. So.
Yeah, you can, and then you can do that. Right. Okay. So let's go back to kind of wrapping it up here. First and foremost, I want to thank you for your time, your efforts. I'd love to have you back.
Sure.
And, I think what would be great is if you could tell me, in your experience, a huge successful outcome on both sides, what that looked like, what those cases looked like, just from a storytelling perspective. I think that'd be interesting.
Like from a landlord, like eviction case?
Both. Yeah, from a tenant and a landlord. What have you seen that's been the most wild?
Like a wild eviction
Like an
case?
Outcome, yeah. Like you didn't think it'd go that way, but it did. In trial, right, you have a foreman that's selected in the jury room, right? Like who the leader is of the...
we don't know who it is.
Right, but afterwards, right? Like when they come out, they speak. Yeah. But I'm saying, don't you ever play that game where you pick who it is?
No.
Oh, really?
I'll never know who it is.
No, but like
in the beginning, you can try
based on how they look at you. Are they writing down notes? Are they yawning in the back? Or are they like?
No. I don't really do that.
I worked for an attorney, and of course I was an attorney, so I couldn't speak, and I would be taking notes. I'd try and pick out who the jury foreman, I don't know, it was just like a game that I played, but it was a PI lawyer though.
But I'm trying to think if I have any crazy stories.
Yeah.
I mean,
it's routine and ordinary.
Yeah, it is routine.
Pretty much, right?
Yeah.
Yeah, it's like...
there'll be people who evict for all sorts of reasons. We have a daughter who's a client who's evicting her mom.
Oh, wow. Yeah, I wouldn't want to be in that family.
So I would say family evictions are also always the craziest.
I bet. Do you feel like you ever get like a directive verdict from the jury where they just don't like the landlord? And so they'll just say, I don't care about the evidence. Screw this guy.
So far, no, because what I like to do is after my jury trials, you are allowed to voluntarily speak to the jurors.
Interview, right.
Yeah, you're allowed to ask them if they want to talk to you.
Sure.
And there'll be one or two that'll say,
they'll talk afterwards.
Talk. And she's like, I couldn't vote in your favor, but I hated the tenants.
Ah, so it's the other way around, usually. Yeah. Okay.
She's like, I knew she was lying.
So there was some sort of issue of fact that made it like that.
Yeah.
Okay.
And I was like, wow.
See, to me, that's interesting. I just love that stuff. I love hearing like how it kind of, what the thought process was on the verdict, and why they answered it is casino. It is a little bit of a lottery,
And I had someone else. They're like, yo, I liked you a lot. You were straight to it.
So I like the idea of a professional jury. I don't know how you feel about this.
What does that mean, professional?
It means that, like, think of it like as a grand jury, but what you do is you have a true cross-section of people in life that serve on juries.
Okay.
Because I think typically who serves on juries are like federal employees or government employees, teachers, because those are the only people that can usually get the time off work to be in the jury. Although I was, hanging out the courthouse not that recently, but
there's a couple of juries I had. Very wide cross.
Oh, that's good.
There are different backgrounds though.
No,
the Valley Court would have different people than Santa Monica Court.
Sure. No. I guess what I mean is I think that we're entering a world of high level sophistication, whether we're seeing rules against, AI and antitrust, and there's all these state laws that are coming that they're saying is for general business, but I really think they're directed towards us. So price fixing. So if you enter in, if you have an AI agent, do an aggregate of your rents in the area, that's going to be viewed unlawful in this next legislative cycle. I predict, right? I think these are the discussions that are happening. What is AI going to look like? By the way, what do you think AI is going to look like in your profession?
In my profession?
Do you think there'll be AI mediation?
No.
No,
you need a person. Believe it or not, my settlements best come when there's a judge as a mediator, because the judge will say, hey,
they know.
I'm the judge. I know what's going to happen.
I think the judge is a true decider of facts because they've seen it.
I had a trial once. In the middle of the trial, he's like, let's stop, come to my back room. I want to talk to both sides. And we settled.
Nice. Because the judge is like, I'm going to rule in this particular way.
The judge didn't say what way we're going to rule.
But he's hinting heavy.
You know what? We need to settle this.
Right.
We need to settle this.
And it's worked, right?
And it worked.
Yeah, no AI can do that.
No.
For now.
No,
I
doubt it. But AI in my field, I don't think will take over.
Okay.
It's just too hyper technical. I don't even trust AI. I don't think people should follow AI when it comes to legal advice.
I agree with you on that.
Yeah, it gives
terrible advice.
Laws. I had someone the other day call me and said, "Oh, I'm allowed to go inside the tenant's unit at any time."
Yeah, because AI told them so.
AI. And I'm like, that is 100% wrong. You cannot go in anytime.
No.
Civil Code 1954. You cannot go in anytime.
Right.
You need a legal reason to enter. So,
and you give notice and then you can go in and take a look. But
yes.
Okay, so I was wrapping it up, but then we kind of went off another deep. I don't even want to use that or not, but I just want to share with you. I think I'd love to have you on again. I kind of came in very supportive of legal counsel. Someone in my business, in my profession. I typically, it's one of those things if I can impart on anybody, and I think you're just gonna be like, yep, sounds right, John. When in doubt, call your lawyer.
100%.
Right, and this is in business. This is in this isn't just for housing providers. I think we live in such a litigious kind of society, and it just saves you money in the long run if you can get really great advice and counsel. And do you take retainers where somebody will just hey, I'm going to need to use, you could bill against it, or is it particularly for just cases?
We do flat fees.
Okay.
So you'll just pay a flat fee. We'll do a property review, and then I'll let you know what you need to do, what you don't need to do. But we also do habitability defense as well on retainer.
Oh, really?
Yeah. That's been big lately.
I bet. Well, it is. Yeah, we're seeing more and more of it.
More and more, yeah.
And the number one thing, again, is documentation. I don't want to rehash 100%. It, but it all comes down
100%.
to, yeah, you got to write it out.
I'll be like, did you send a letter saying, hey, we want to come in? They'll be like, I don't know what you're talking.
So what's the best way to get a hold of you if someone wanted to reach out and pay for that?
Call my office, they'll do an intake on you. We'll take notes. I'll review the intake depending on the situation. We'll see what documents you need to fill out or what you need to, or I'll speak to you and we'll figure out a strategy and go from there.
And you would say that other than habitability, eviction is your primary, like your wheelhouse and what you do most?
Yes.
Okay.
Yeah.
Like you do well.
But there's no guarantees.
There's no guarantees there. I was trying to do a plug for you.
Am I knowledgeable?
You're the house.
If I'm knowledgeable in
you play baccarat. It's a statistically advantaged game.
I am the guy for evictions.
Yes. All right, you're the eviction guy. All right, yes. I like that. Hey, so much. Thank you so much for your time. I really appreciate it. This is John Edmund here. You're our third victim on the podcast. So we really appreciate you coming in. I'd love to have you again.
Of course.
And just want to thank you for your time and being a business affiliate for the Apartment Association of California Southern Cities. So with that, thank you so much and have a blessed day.
Thank you.